Thank you, my Lord. I was about to take you to one last Strasbourg authority before I turn to the upper tribunal decision, and it's the case of Mendizabal, which is at page 1175, behind tab 26 in the second volume.
Just one moment, Mr.
Have you got your own?
Yeah, it must be.
Sorry, can you give me the number again?
Yes, 1175, 1175.
Thank you.
And I take you to it now, but partly because of what the upper tribunals say about it, and also because my learned friend relies on it. It's actually really a case that is very different to all the other ones we've looked at. And you can see that if you look at the facts, which are there in the head note. Ms. Mendizabal was a Spanish national who had, at the time of the Strasbourg judgment, lived lawfully in France for 31 years, from 1975 to 2006. She was not an illegal migrant at any stage. And what happened to her is that she had different stages in her time in France and different kinds of residence permit. For the first 10 years, she was given a yearly residence permit. And then from 1989 to 2003, she was given very short residence permits of only a few months. And finally, from December 2003, she was given a 10-year permit. And what she complained of was those 14 years of being given these very short residence permits of a few months. And so there's a danger when if one refers to this as a limbo case, as the upper tribunal later does, of conflating two very different situations. The situation of Ms. Mendizabal, who was in France lawfully, but only had very short periods of residency, lawful residency, and the situation of someone who's in the country unlawfully, and the state refuses to make their stay lawful. Thank you very much. It's also important...
Were they continuous periods of residence?
Yes. And it's also important to see why this case succeeds. And it succeeds because what happened to her wasn't compliant with EC law or French law. You can see that in paragraph 74. Paragraph 74 on page 1189 says that as regards the first point, the court finds that for the period under consideration, French and community legislation provided as follows. And then if you look at the indented bit of the indented bit, a residence permit shall be granted as of right to foreign nationals having evidence by all means having ordinarily resided in France for more than 15 years, or who's been in a lawful situation for more than 10 years. And they say, well, given she's been lawfully resident, she has, as far back as 1989, which is when she'd done 10 years of lawful residence, satisfied all the conditions. And so the conclusion comes in the next page, 1190, paragraph 79, that what happened to her was not in accordance with the law. Under French and community law, having done those 10 years of lawful residence, she should have been given permanent residency. So, if I move on to section 3, that's the decision of the upper tribunal. I'm not going to go over the facts and how they are dealt with in the upper tribunal. Ground one, as I'm sure you will have seen from our statement of case, ground one before the upper tribunal had two limbs to it, two parts to it. There was a common law challenge and an Article 8 challenge, what we called 1A and 1B in our statement of case. And although the focus of these proceedings is the Article 8 part, I would like to pick up the judgment of the upper tribunal first when it's dealing with the common law part. And that's at 271. The reason I pick it up there is because of some of the findings of fact made under the common law section of the judgment.
Could you give us the paragraph number?
Yes.
Some of us are working from a hard copy of the document.
Yes, so it's from paragraphs 107 and following.
Thank you.
The heading above 107 is removal impossible? And that's relevant to the common law challenge, which was based on Kadir and the reading of Kadir and suggestion that if removal is actually impossible, then common law requires you to grant leave to remain. And you can see the submission in paragraphs 107 and 108 on behalf of AM that removal was impossible. And you pick it up for the last sentence of 107. The sheer length of time may nevertheless be indicative of the impermanent impossibility of removal, and Mr. Carnick contends that this is indeed the position. The Upper Tribunal reject that submission. At paragraph 114 on page 272, they make a general observation. They say that a person who contends that his or her removal has become impossible because of their own refusal to disclose their true identity to the Secretary of State faces the obvious problem. It lies within their power to change that state of affairs. And they say that a Kadir impossibility challenge based upon such stance is highly unlikely to succeed because they can always change their mind. And paragraph 115, they recognise an exception along the lines of the one I was mentioning earlier, for those who've effectively forgotten their identity. They refer to people who've become so mentally ill as to be permanently incapable of recollecting who they are. But importantly, they make a finding that that is not this case. They say in the present case, however, the evidence does not disclose such a state of affairs. As we shall see, however, the applicant does have a number of medical issues which, whilst not of such apparent severity as to render him incapable of exercising free will or discerning the difference between truth and falsehood, or to have irrevocably destroyed his memory, nevertheless impact upon the practical ability of the respondent to remove the applicant to Belarus. So that is a finding that his medical issues do not render him incapable of telling the truth about his identity. Paragraph 116 is a finding that the applicant has not been candid in the past about sufficient aspects of his personal information so as to enable the respondent to effect his return were the Belarusian authorities to be cooperative in this regard. It doesn't stop there. My learned friend in their statement of case identify this and say it's the high point. It's not the high point. It doesn't stop with were the Belarusian authorities to be cooperative, because we have even more important findings at paragraph 117. Here they say, so far as concerns the submission that the Belarusian authorities would not readmit the applicant, even if he told the truth, the Court of Appeal at paragraph 43 in 2014 judgment specifically rejected this aspect of the applicant's case on the basis that the first-tier tribunal judge decided that question against the applicant, as did Upper Tribunal Judge Southern. Again, no satisfactory case has been made for us to reopen that matter. So they are there finding that if AM had told the truth, he would have been returned to Belarus. That is a finding on causation. And this, and together with 115 on capacity, are, we say, the most important factual findings. And we say they should have been determinative. Now, having dealt with the common law case, at paragraphs 119 and following, they turn to Article 8, and they do it through the prism of the 4 stages from RA Iraq. And in paragraph 120, they look at stage 1, and they place emphasis on the applicant having been in actual limbo for over 20 years. And they say this at the end of paragraph 120, the period far exceeds the 14 years which led the Strasbourg court to conclude that Ms. Mendizabal should have her status regularized on Article 8 grounds. And we say that is a misreading of the Mendizabal judgment, which I just took you to. Her case was nothing like AM's. It didn't turn on 14 years of limbo or unlawful residence. It turned on the fact she'd lived lawfully for 10 years and had a right under French and community law. But this misreading of Mendizabal may have influenced the upper tribunal to give undue weight to AM's unlawful residence. The second stage we can skip. At the third stage...
Sorry, and just on that, I mean,
yes.
Mendizabal, the ruling didn't depend on the proportionality balance at all. I thought it just depended on not in accordance with the law, and they said expressly they didn't go on to the balance.
Yes, that's right.
Whereas this, just to make the point, this part of the judgment is concerned with the balance ultimately.
Yes, that's right. The third stage, which is the sort of factual findings, at this point, they refer back, paragraph 123, they refer back to the time spent in the United Kingdom. They go through the various offences he's committed. But can I just draw attention to this in paragraph 123? They find in the third line, the applicant has no family in the United Kingdom, but we accept he has some, albeit minimal, private life through friendships. So this is a very far cry from the sort of case that you, my Lord, Lord Sales, were referring to in the sentence that was quoted in Rupiah, of a case where there's some particularly strong feature of the private life that means that it can be given greater weight than 117B4A would normally allow. This is a case where actually on the findings there was minimal private life. In paragraph 125, they refer again to the time spent in the United Kingdom being very great. They speculate that it's probably the longest time spent in limbo. And then at the end of the sentence, the end of the paragraph, sorry, they effectively seem to qualify something they'd said earlier about how he had the capacity to tell truth from lies, and they acknowledge that. They said that his difficulties stem from his entrenched stance, but they take into account the fact that he would have been treated as a vulnerable witness due to his physical and mental health problems. We find it difficult to understand why his choice to lie should be mitigated by his having physical or mental problems that don't prevent him from knowing or telling the truth. Paragraphs 126 to 128 summarize the medical evidence, and paragraph 129 is the conclusion on that. And effectively, the conclusion, you pick it up at the bottom of the page, is that it's plainly unlikely that if he were to be given leave to remain, he'd become a model member of society. But they place certain weight on Ms. Good's evidence, which shows that he retains capacity for self-improvement. Of course, having capacity and being likely to do something are different things. And so really, this finding is that leave to remain would offer a slim possibility of improvement in AM's antisocial behaviour. They then move on to stage 4 in the RA guidance. Paragraphs 130 to 132, they cite 117C, they recognise in paragraph 132 that the applicant can't satisfy exception 1. He's not been lawfully resident in the UK, and he's not socially and culturally integrated. So they recognise that he would have to have very compelling circumstances. Paragraph 133 relates back to paragraph 71 of RA Iraq, which is that paragraph which I took you to and said it's capable of being misinterpreted. The paragraph which talks about the public interest being extinguished and doesn't really look at the public interest beyond the removal of that individual. And what they find is, well, actually, we're not in the territory of paragraph 71. And they say, at the bottom of the page 276, the public interest, they say, we do not consider that in the present case, the public interest can be said to have been extinguished. It's the applicant's refusal to be candid about himself that has led to him being still in the United Kingdom in 2020, having arrived here in 1998. That reiterates the finding of causation. And during his irregular presence in this country, he's committed criminal offences. So that's the highest they've put it. It's not extinguished. Paragraph 134, they recognise that paragraph 71 needs to be carefully read, and they recognise words like normally. Paragraphs 135 and 136 are important to our third ground, because what the upper tribunal does in these paragraphs is conflate two different factors of the public interest. Conflate public confidence with deterrence. The domestic case law on deportation in Article 8 refers to three facets of the public interest. The first is protecting against reoffending by the individual. The second is deterring other foreign nationals from committing crimes by leading them to understand that deportation may well be a consequence. And the third is public confidence, building public confidence in the immigration system. What paragraph 135 does, and indeed paragraph 136, is they start by looking at public confidence and they conclude with deterrence. So they, in the first few sentences of paragraph 135, they start by talking about public confidence, but then at the end, last sentence, they say the stark question is whether that principle of deterrence is likely to be damaged. And this becomes an even bigger problem in paragraph 136, because all of paragraph 136, other than the conclusion in the last sentence, is about public confidence. It's about what the British people might think. And having looked at what British people might think, they leap to a conclusion on deterrence. Accordingly, they say in the last sentence, a grant of leave to the applicant at this point is unlikely to encourage others to follow his example, thereby leading to a general weakening of the immigration system. And we say that is a non sequitur, just because the British public may not think that he has benefited from his unlawful life in the UK. It doesn't follow that granting him leave to remain won't encourage others to follow his example. And others in this context must mean foreign nationals, not British nationals. And following his example can mean different things. In public policy terms, what's most concerning about this case is not the incidental details of his life and whether he was addicted to drugs, but the fact that he has obstinately refused to disclose his identity. And so the concern is that others may think, other foreign nationals may think, that this is a case where someone has effectively been rewarded for the persistent refusal to be truthful about their identity. Paragraphs 139 to 143 consider paragraph 276 ADA of the immigration rules. It starts with the submissions of my learned friend raising it. Paragraph 142, the first sentence is missing some words. The Upper Tribunal say, in approving the rules, Parliament has acknowledged that a period of 20 years spent in the United Kingdom is an important yardstick, and I underline that, in determining whether the right to respect for a person's private life, full stop. The missing words must be something like requires a grant of leave to remain. This is a misdirection in our submission. Parliament has never accepted that 20 years of unlawful residence is an important yardstick in determining whether Article 8 requires a grant of leave outside the rules. On the contrary, in section 117B(4)(a), Parliament has given unqualified guidance that little weight should be given to private life in the UK, established while in the UK unlawfully, however long. Paragraph 276 ADE3 does...
Sorry, just on that.
Yes.
As you showed us within paragraph 276 ADE, that's one, the 20 years is one condition that needs to be satisfied, but there is a whole host of other conditions.
Yes, exactly. So it is one condition that might lead to a grant of leave, and it gives significance to 20 years, not including imprisonment. But it's part of, we say, a balanced incentivization policy, which is more favourable than you would otherwise get under Article 8 principles and 117B(4)(a). The 20 years is the 20 years condition is the incentive, if you like, for illegal migrants to meet the suitability requirements. And it only works as an incentive because the alternative, which is a freestanding Article 8 claim, in that alternative, 20 years would not have a special significance. The rest of paragraph 142 misses the point. It looks at the fact that there's reference in parentheses to discounting any period of imprisonment. But as I explained when we went through the rules, that's just for the purposes of counting. When you read that together with the suitability requirements, it's plainly not saying that periods of imprisonment of 1 year or more are irrelevant. On the contrary, they disqualify someone. Paragraph 143 looks very much like the application of a kind of near-miss rule to a 20-year yardstick, which shouldn't have been a yardstick at all in this context outside the rules. Paragraphs 144 to 146.
So in 143, are they saying that if you discount the prison sentences, he hasn't yet accrued the 20 years?
They're saying we haven't quite bothered to do the maths, but we think it's there or thereabouts.
Can you help us with the math?
Not off the top of my head, I apologise.
And is the period of imprisonment the period actually detained in prison, or is it the prison sentence?
My understanding is it would be the period detained in prison.
I'm sorry to be picky again, but
yes.
It might be useful for us actually to be given the figures.
Of course, my lord. I apologise for not knowing the answer off the top of my head. Then paragraphs 144 to 146, the tribunal purports to consider the public interest, but they focus on AM and the effect on him. There's no consideration in these paragraphs of the wider public interest in deterring others and the risk of perverse incentives, and also the impact, as my Lord points out, on public resources. Paragraph 147, there is a reference to 117B, but they don't spell out what 117B entails, nor do they explain how their decision can be reconciled with the generalised normative guidance that little weight should be given to his private life. As it happens, they make a mistake in thinking that it's a precarious case rather than an unlawful case, but nothing turns on that, because either way, it's something to be given little weight.
So sorry, which paragraph did they?
147, you see in the third line, they say that he's had at best precarious immigration leave through temporary admission. In fact, temporary admission is not a form of leave to remain at all. It's an alternative to detention. And so he isn't actually in the case of someone with precarious immigration leave. He's someone who's been here unlawfully throughout.
But you say that doesn't really matter.
Really matter. Yes. Paragraph 148 is perhaps the most important paragraph because it draws together the key factors, and it's significant to note what is here and what is not here. And what is not here is any mention of the fact that AM is responsible for his own limbo by lying about his identity. And that, we say, should have been determinative, but it's not even one of the key considerations in this paragraph that sums them all up.
So sorry, does the upper tribunal ever apply section 117B4? Which is the provision that says if medium foreign criminal, little weight to private life.
117C, you mean?
Oh, is it C? Sorry.
Yes, it does. Back at paragraph 130 to 132, that's where they look at the 117C section, and they say exception 1 not met because he's not been here lawfully and he's not integrated.
Right, but I thought it was section 117B4 that said that there's little weight to private life.
It is, sorry, I thought you said, yes. 147. So 147, which I was just taking you to, that refers to 117B. It doesn't specify which of the subsections of 117B they are referring to. They mention precarious immigration
that's
leave.
Section 5, that's why I asked my question. They seem to focus on 5.
Yes.
Do they ever
No.
refer to 4? Okay.
Looking at paragraph 148, as I said, this paragraph, which brings together the combination of things that they think are important, doesn't mention the fact that he's responsible for his own limbo. It doesn't mention the fact that he's been in the UK unlawfully throughout. It doesn't mention the fact that his private life in the UK is minimal. Instead, the things that count in his favour, there are 3 things which are said to diminish the usual public interest in effective immigration control. Those 3 things are all spelt out in the first sentence of paragraph 148. The first factor said to weigh on his side in the balance is the remoteness of removal, combination of the remoteness of the removal. And we say that is perverse and wrong because removal is only remote because of his obstinacy. And it's odd that that is then taken into account as a factor in his favour, which weakens the public interest in effective immigration control. That's the first factor, remoteness of removal. The second is the fact, as it's put, that taking the applicant out of limbo would not materially damage the principle of deterrence inherent in the statutory scheme. Well, we say that's an irrational and unreasoned conclusion. I've taken you to the paragraphs before that really look at public confidence and how the British public would look at it. It's never explained why foreign nationals would not consider that this case was significant and why the principle of deterrence would not be weakened by the effect on them. I'm going there, Richard. You'll have your moment. And the third point is the rationale of the overall rationale of paragraph 276 ADE. And it's clear, contrary to my learned friend's statement of case, that the arbiter tribunal plainly thought this rationale was something that weighed in AM's favour, weakened the public interest in refusing him leave to remain. And we say that's back to front. Properly understood, the rationale of paragraph 276 ADA should have strengthened, not weakened, the public interest in refusing this person leave to remain when he hadn't met the suitability requirements. At paragraph 149, the tribunal, in the first sentence, says that they balance all the relevant factors and they conclude that his case is exceptional in the true sense of the word. Well, exceptional is something that can be lots of different things in lots of different contexts, is not informative. They then say, anyone reading the applicant's history cannot reasonably regard our conclusion as any green light for others to attempt to withhold material relevant to the establishment of their true identity. And we say that is not explained. Why not? This is the third time the upper tribunal has expressed views on deterrence, and at no point have they explained why no one would draw from this case a conclusion that sometimes, if you can reach the important yardstick of 20 years, an obstinate refusal to cooperate may actually be rewarded. And finally, they end by saying the alternative to granting leave to the applicant would be to remove any prospect of effecting the positive changes in his life described by Ms. Good without any commensurate benefit to the public interest. Well, that conclusion links to their earlier focus on whether AM can be removed, but they don't grapple with the public interest which lies behind the statutory scheme, behind 276 ADE, in deterring illegal migrants from being obstructive and incentivising compliance. And we say if that wider public interest is taken into account, it should have far outweighed the slim prospects that a grant of lawful status might lead this applicant to turn around his life. That's the upper tribunal decision. I move on to the fourth stage of my submission, the Court of Appeal's judgment, which is at page 148. Paragraph 3 on page 149 sets out the the 4 grounds that we were pursuing then, only 3 now if there were 4 then. And the first ground was that the decision was inconsistent with Article 8. And one part of that was about negative and positive, but the other part was just about the fact that this was self-induced limbo, that's still our ground one. The second ground is the point on deterrence, which is now ground 3, and the third ground has become ground 2. It was both about near miss and also that the upper tribunal was wrong to treat 20 years as an important yardstick. If we turn to page 161, paragraph 61.
Thank you.
The second sentence of paragraph 61 is our submission on ground 1, and our submission was and is that the fact that he thwarted removal through his dishonesty meant there shouldn't have been any obligation to grant him form of leave. And as I've said, even if we're wrong to think of it in terms of admissibility, it's what we say should have been determinative in any Article 8 balance. The Court of Appeal record that submission. They record the authorities referred to, the Dragan case in Strasbourg, the Hamza case in domestic courts, but they don't, there at paragraph 62, actually squarely address the submission that effectively self-induced limbo, that should be determinative. Instead, what they say is that it's necessary to look at the other grounds first and then look overall.
Or is it because it was common ground that RA reflected the proper approach to dealing with these questions and would encompass the points that you were raising?
Well, that's, I mean, it is, it was always our position that ground 1 did need to be dealt with. Their position was, because neither side is saying we can't follow RA Iraq, we don't need to, we can look at grounds 2 and 3. But we say that's wrong because it's RA Iraq simply doesn't give the answer to the issue in ground 1, which is what happens with self-induced.
Is that what you said to the Court of Appeal?
I didn't say, I can't remember off the top of my head exactly how I put it. I can go back to the skeleton argument. But we did say to the Court of Appeal it should have been determinative. We definitely said that. And so it was our case that the RA Iraq guidance wasn't going to tell you the answer. The answer came from it being self-induced.
And sorry for pursuing the point, but was it your submission in the Court of Appeal that Article 8 wasn't engaged?
No. Paragraphs 63 and following look at ground 2, which was how the upper tribunal had approached deterrence. And if you look at paragraph 64 on page 162, they record my submission, and then they say this at the second half: it seems likely that this part of the judgment was directed to submissions about concerns that members of the public in the UK might have in the immigration system if AM was granted some form of leave to remain. This paragraph was not wrong. It was not central to the reasoning of the upper tribunal. So what we say about that is it's not an answer to the submission. They say, well, they were probably thinking about public confidence, but that's the problem. They look at how British people react and impact on public confidence. They don't properly analyse how foreign nationals would respond. And with respect to the Court of Appeal, it's not right to say that it wasn't central to the reasoning. This observation is one of the 3 key matters relied on in the upper tribunal's decision that the public interest is weakened in this case, and it's referred to no fewer than 3 times. Paragraphs 66 and following look at what was ground 3 and 276 ADE and how that was treated. And if I take you to page 163, paragraph 68 records my submission that the rationale of 276 ADE was to encourage and reward compliance with suitability standards. And then at the end of paragraph 68, the Court of Appeals say that they don't accept that the upper tribunal misunderstood the rationale as suggesting an amnesty would be granted. The judges didn't say that, but that's not a complete answer to the point, because the key point wasn't that the upper tribunal had misunderstood 276 AD as an amnesty. The key point was that the upper tribunal had misunderstood the rationale of 276 AD as something that weighed in AM's favour, and they'd misunderstood in thinking that 20 years was an important yardstick, even in an Article 8 claim outside the rules. In paragraph 69, they quote what the upper tribunal said, and they quote the sentence about 20 years being an important yardstick. And they say this was an accurate summary of the effect of paragraph 276 ADE of the immigration rules. Well, with respect, it's not an accurate summary of what Parliament acknowledged, and it's not an accurate summary of the effect in a case like this, outside the immigration rules. Secretary of State created a rule giving special significance to 20 years residence if the illegal migrant refrained from the prescribed behaviour. And that is not an acknowledgement, either by Parliament or the Secretary of State, that 20 years is an important yardstick and an Article 8 claim outside the immigration rules. On the contrary, we say Section 117B and the Strasbourg case law both indicate there is no special 20-year yardstick in a freestanding Article 8 claim. Paragraphs 74 to 75 come back to ground 1 and really rely on RA Iraq to suggest that this was just a sort of balance exercise that they can't interfere with. It never really addresses the square point that because this is self-induced limbo, it's not a simple balancing exercise. It's a case where that factor is determinative. So, my lords and my lady, that deals with Section 4, the submissions on the Court of Appeals judgment. I'll now just briefly take you through our last section, Section 5, our case in a nutshell, and respond to some of my learned friends' points on that. And so if I can summarise our ground 1, and I can put it in 3 different ways. The first is, if we're right about the Gilberg exclusionary principle, then, properly speaking, this should have been a case where Article 8 was not engaged at all, because it was a complaint about suffering which is a foreseeable consequence of misconduct. That's the first way of putting it, the Gilberg exclusionary way. The second way of putting it is that even if we're wrong about that, this was a case where, because of the limbo being self-induced, a balance could only really be struck one way.
You mean only struck one way on the facts of this case, because there might be private life that was much stronger and built up with many more ties that would lead to a different balancing exercise? Or are you saying the balance can only be struck one way in every case?
I'm saying, on the second way of putting it,
Yeah.
that if someone is complaining of a limbo that is self-induced, then balance can only be struck against them. That's the second way of putting it. The third way of putting it is that this is a case where, given all the facts, there was only one way of putting it. Given the minimal private life, and given the very powerful factors in this case, weighing against this appellant, his obstinacy, non-cooperation, and his criminality, in that context, and given the wider public interest, there was only one way of striking the balance. So if I then turn to my learned friend's statement of case, just respond briefly to some of the points made here. The relevant parts are at page 110 and following.
Sorry, do you mind giving us the paragraph?
Of course, paragraph 22 and following.
Thank you.
And in paragraph 22, my learned friends say that even if we were right about the effect of self-induced limbo, it wouldn't arise on the facts. And they say at its highest, the facts are those stated 116. But as I pointed out when we were going through the judgment, actually it's 117 that's even more important. And that makes clear that the non-cooperation was causative. The next point is paragraph 28 on page 111.
Before you address that, you said at an earlier stage that the Gilbert-Berg exclusionary principle has no relevance to family life. And that is, it is not an exclusionary principle. Article 8 will still apply. That's what I understood you mean. Do you also say that it has no relevance to the balancing exercise under Article 8 in relation to family life?
Well, the test itself doesn't impact on the balancing exercise. However, if one were in an Article 8 family case and you were doing the balancing exercise, then of course someone's misconduct may well be relevant. Your standard deportation case, for example, where there's someone with family in the UK, you are absolutely balancing the extent of the criminality and against the impact on the family. So in that sense, at the balancing stage, of course, misconduct is relevant, but no, the Gilbert exclusionary principle is something in the case law that you look at right at the start before you decide whether Article 8 is engaged at all.
And then just to clarify matters, in relation to the period, the number of years that an individual has been present in this country, ordinarily, the longer the period of time, the greater the ties, the greater the private life, the greater the family life. But in a sense that detracts from actually concentrating on what is the family life and what is the private life. So having a rule or a yardstick of 20 years or 10 years, whatever it might be, detracts from actually looking at the facts of this particular case and this particular individual. And so you're not suggesting for a moment that 20 years isn't a doesn't give rise to an opportunity to develop family life, but you're saying that if you just look at the facts of this case, it hasn't occurred.
That's absolutely right. And one can see why, if you're looking at immigration rules and you want something clear and simple for people to apply, you might have a yardstick, as it were, because it makes the decision-making easier. You've got kind of 20 years, you can tick that off.
One might say that's why you have it in 276 ADE.
Exactly.
Giving a set of conditions to essentially officials of the Secretary of State to work through in order to see whether someone should be given leave to remain. So it makes sense to have a bright line rule when you're operating the system in that way, but it might be said Article 8 doesn't usually operate on the basis of bright line rules.
Exactly, and sometimes that bright line rule can be more favourable than you'd get in a freestanding case for the sake of administrative convenience or for the sake of incentivising or for other reasons. But if you're going to an actual Article 8 balance, such as you would get if you went to Strasbourg, then of course you don't just look at the length of residence, and what is much more important is the strength of the private life or the family life or whatever it may be. And simply saying I've been here a long time is not enough.
I'm sorry to persist, but you said that the Gilbert exclusionary principle doesn't apply in relation to family life because of its impact on children who are totally innocent. But then you say, on the other hand, oh yes, it does when you come to the proportionality exercise, because you take it into account then. For instance, in an employment situation, in the context of employment, if a person, by his misconduct, loses his employment, of course that's going to impact on the rest of the family, because they're not going to be well off, they're not going to be looked after as well. And the exclusionary principle, the fact that the prime actor has, by his misconduct, had that impact on his family, is a matter to be taken into account, surely, at the discretionary stage.
It is, yes. Absolutely it is. Sorry, what I meant to say, or was trying to say, is that in a family life case, it's not an exclusionary principle. There's no exclusion simply because it's a foreseeable consequences of misconduct. In a family life case, you're having to balance the extent of the misconduct or criminality, whatever it is, against the consequences to a wider range of people. But of course, you take into account the seriousness of the misconduct when you're doing that balance.
Which Strasbourg authority says that the Gilbert principle does not apply in relation to family law?
I don't know of one, and in the note...
We're making the law, then, is that right?
Well, in the note I'm hoping to provide overnight, yes. I'm simply going to say that we don't have a Strasbourg authority that explains why Gilbert exclusionary principles don't apply in deportation cases. We don't have a Strasbourg authority that says this is the boundary of the Gilbert principle. I'm just simply doing the best I can, looking at the different strands of case law to try and explain that.
I mean, I think in the passages that you showed us, they all just talk about private
Yes, life. That's right.
I mean, it might perhaps be said as an objection to the idea that the Gilbert principle applies to immigration cases, that typically they can mix up private life and family life almost in inextricable ways.
Well, sometimes they do, but sometimes they don't, like in a case like this, where it's just about an individual's private life and there is no family life.
But if you're going, I mean, in the sense, this is an easy case for you to say the Gilbert principle applies, but there'll be lots and lots of other cases where there are aspects of private life and family life all mixed up together, which typically come into the proportionality balancing exercise. It seems to make it very complicated to say, well, Gilbert principle, you have to strip out some bits of that, but not others, and you can have debates about which side of the line something falls in an immigration case. I want to put this to you, might it not be said that the more natural inference from the fact that there doesn't seem to be any authority from Strasbourg saying it applies in an immigration context, that Strasbourg doesn't think it does apply in an immigration context, partly for those sorts of reasons?
I don't think that is the only inference. It's certainly been applied in what we call employment-related contexts, which are not just about someone who's employed by the state, but someone losing a right to do a certain form of work. And you could say this case, you could describe it as an immigration context, but you could also describe it as an employment-related context, because the key thing he's complaining about is not removal. That's off the table while he continues to be non-cooperative. The key thing he complains about is not being able to work, which is quite similar to the context in which the Gilbert exclusionary principle has been applied.
Yes, thank you.
I was just about to move on to the second point under ground one, and that's page 111, paragraph 28. The submission there is made that effectively the tribunal did take into account AM's own actions.
Paragraph?
Paragraph 28. Secondly, alternatively, AM's own actions to describe the Secretary were taken into account. They form a starting point. Well, if we're right in the first or the second way we put it, it shouldn't have just been a starting point. It should have been the determinative fact in the case. But even if we're left with a third way of putting it, they plainly didn't give it. They didn't treat it as the important consideration it should have been. On the contrary, oddly, his obstinacy ends up being a factor in that final reckoning of the key factors. It counts in his favour because it makes removal remote. The third and fourth point go back to their submissions on the Gilbert line of authorities. And as I hoped I pointed out in going through them, that those authorities are not limited to reputational damage cases. And it is an exclusionary principle. And I will put in, I hope, one page, I don't want to overpromise, but I hope one page, our best attempt to explain the limits of that principle and why it's not featured in a deportation case. The fifth point is at page 123. Paragraph 81. And this is a straw man argument. My learned friends submit the appellant glosses over AM's personal circumstances. The Secretary is right then, however compelling, the personal circumstances of an applicant are irrelevant. Well, that's not right. We accept that personal circumstances need to be taken into account. They might be compelling. For example, if it was someone who was so mentally incapacitated they'd forgotten their real name. It's just that wasn't this case. So we don't say that they should be ignored. It's just, in this case, they weren't compelling. That's ground one. Ground two, we, in our case, make our submissions. If I just take you to our case, it's at page 96, and it's paragraphs 74 and following, where we set out our submissions on how the upper tribunal erred in its consideration of paragraph 276 ADE. And in paragraphs 76 to 77, I can summarize this as this point, that 20 years is an important yardstick in 276 ADE cases, but it shouldn't be in claims outside the rules. And the rationale of referring to 20 years in 276ADE is not to reflect some general Article 8 principle, 20 years an important yardstick. And the Upper Tribunal misunderstood that. And the second point we make at paragraph 80 is that 276ADE of the rules should be read together with section 117B4A. And that's something the Upper Tribunal never did. And that may be one reason why they misread the rationale of 276ADE as something weighing in AM's favour. And in fact, by treating it as a yardstick in a freestanding Article 8 case, they were departing significantly from the normative guidance of 117B4A. Now, if I return to my learned friend's case, to page 125, paragraph 88, paragraph 88, my learned friend submits that this argument relies upon inferences rather than the actual words by the Upper Tribunal. And we submit that's not correct. We rely on the actual words of an important yardstick. And we rely on the actual words in that paragraph where the rationale of 276ADE is taken into account as a factor that weakens the public interest in immigration control. The next point is at paragraph 95. Paragraph 95 to 98. And I think I can summarize this submission as that the Upper Tribunal didn't really place much significance on the length of residence, but we say that's irreconcilable with the decision and the reference to the yardstick and the multiple references to how long he'd spent in the UK. The rest of the submissions really attack our position to say that the overall rationale should weigh against AM. But that doesn't get to the heart of the ground, because the heart of the ground is that the Upper Tribunal put it in the balance in his favour. And what we say is, if anything, it should weigh against him. It doesn't really matter if we're right about that, so long as we're right about the first thing, it shouldn't have been in his favour. But, for the sake of completeness, we do think we're right about that. And if the 20-year yardstick in 276ADE tells you anything, it tells you that those who don't meet the suitability requirements would need to do a lot more than simply spend 20 years in the UK to outweigh the normative guidance in 117B4A. And we don't accept the submission that the intention of 276ADE was to codify Article 8 case law. There simply isn't any Article 8 case law giving a special significance to 20 years. I move on to the final ground, ground 3, and I'll take you back to our statement of case. To page 100, paragraph 88 and following. The first, we submit that there were two connected errors. The first error we set out, paragraph 89, that's looking at the wrong cohort. British public. And another way of putting this is that the Upper Tribunal conflated two separate strands, the of the public interest in maintaining the confidence of the British public with the public interest in deterring foreign nationals from breaking immigration law. And a further related error is the one we set out paragraph 90, which is that the upper tribunal wrongly focused on the incidental details of AM's life. And the nub of our criticism is at paragraph 92 on page 101. When you're looking at deterrence, you should focus not on what the individual has done with their time in the UK, but rather on the fact that every time you make an exception to a general rule, you weaken the rule. In paragraph 93, we've referred to some of the authorities on deterrence and the public interest in a deportation case. And I will just very briefly take you to one of those authorities. I'm still confident I'll finish in time. It's at page 1532. It's the case of O.H. Serbia, Lord Justice Wilson, as he then was. And it's behind tab 41. This was a deportation appeal involving a Serbian national who, after their offending, had done a great deal to try to avoid there being any risk of reoffending, to rehabilitate himself, in other words. Page 1539 contains two citations from a case of N. Kenya. The one in the middle of the page is a citation from the judgment of Lord Justice Judge. Lord Justice Judge there talks about the public good and the public interest. And if I pick it up about 5 lines down, he says they include an element of deterrence to non-British citizens who are already here, even if they're genuine refugees, and to those minded to come, so as to ensure they clearly understand that whatever the circumstances, one of the consequences of serious crime may well be deportation. The Secretary of State has a primary responsibility for this system. Its decisions have a public importance beyond the personal impact on the individual or individuals who would be directly affected by them. And then it goes on to say at the end that the adjudicator must look at that wider public interest. And then we say that is what the upper tribunal failed to do. They really focused on the personal impact on AM of granting or refusing him leave. Paragraphs 15A to C, Lord Justice Wilson summarizes the propositions, and you can see he draws out 3 distinct facets of the public interest. And B and C are different. B is deterrence, and C, a further important facet, is public confidence. And we say those should be kept separate. They may or may not overlap, but you certainly can't just look at one and assume the answer to the other is the same. Paragraph 16 on page 1540, Lord Justice Wilson speaks there about a conflict between his head and his heart. And he says at the start, in my heart, I would wish to propose that this appeal be allowed. And he refers to the efforts of the appellant to rehabilitate himself, which he says are almost heroic. But he says that he's supposed to be ruled by his head and not his heart. And really what he's talking about there is focusing on the wider picture, not the individual. His heart is focused on the details of the particular appellant's life and the heroic efforts of rehabilitation, but the head has to look at the wider picture not just would this individually reoffend, but what would it do or say to others? What would it do to the principle of deterrence? And the other thing to note about this picture, we say that's the trap the upper tribunal fell into, of looking at the personal circumstances, but failing to properly look at the wider picture. And the other thing to note about this paragraph is if you look at about halfway down, paragraph 16, he says, I have paused for thought. Quite hard to pick it up in such a long paragraph, but what he says is, I have paused for thought about the fact that in his written reasons for deportation, the respondent had himself not referred specifically to these features. That's to say, public confidence and deterrence. But he finds that that is still no reason to allow the appeal, because those are factors you need to look at in every case. And whether or not they were referred to in the decision under appeal cannot affect the existence or otherwise of an error in law and the determination. So if I turn then back to my learned friend's case on ground 3, page 130, paragraph 114, paragraph 114 on page 130, my learned friends make somewhat tentative submission. They say, this question presupposes that in the case it's not about deportation, removal, or a right to remain, that the deterrence principle is necessarily in play, and the Secretary has not shown it to be. And we say that plainly the deterrence principle, or a principle of deterrence, is in play in this case, and the upper tribunal was right to look at deterrence, albeit that they didn't look at it properly. We say that deterrence is plainly one part of what is sometimes described as the compliant environment, and that's never really been disputed, and that was recognised in RA as well as the upper tribunal. So the upper tribunal was right to consider deterrence, but just didn't do so properly. The second point made at paragraph 116 is suggested that the upper tribunal was provided with neither submissions, evidence, nor policy on this aspect. And there's a reference to a decision to maintain temporary admission immigration bail made on the 29th of January 2019. It said that decision made no mention of deterrence. Well, there are two answers to that. The first is that following the principles in OH Serbia, which I just took you to, it's something you need to look at whether or not it's been mentioned in a decision letter. It's part of the underpinning reasons for the policy in the first place. And the second point is that it's not actually factually correct. I'm not sure what my learned friend's referring to with a decision of the 29th of January. There isn't any such a document from the 29th of January in the SFI or chronology or bundles. There is an internal review note, not a decision, but an internal review note of the 25th of January. I don't need to take you to it, but for your reference, the page number is 375. And it refers to a significant public interest question in the case. And obviously, that significant public interest question was the fact that if AM were granted leave to remain, it would weaken the general public policy in deterring illegal migration. The third point at paragraph 124 on page 132, my learned friends submit that the upper tribunal was aware of a potential risk in respect of the deterrence principle. Well, with respect that, we say doesn't align with the judgment, which effectively discounts there being any such risk. And finally, paragraph 126, it's submitted that on our logic, deterrence should be treated as a trump card. And that's not our logic. We're not saying that if you get to a balancing exercise, deterrence is a trump card. We're just saying if there is a balancing exercise, then the impact of making an exception to the general principle of deterrence needs to be weighed in the balance. And here it was not, because it was wrongly thought there would be no such impact. Thank you, my lords and my lady. Those are my submissions.
Thank you.
If I
Lord,
could,
there's a question.
yeah, I can just bring you back to the 20 years point. And as I understand it, you accept that the duration and degree of interference with family life should be considered under Article 8.
Yes.
Right. And does that extend to future interference?
So, forgive me, my lord. Can you explain what you mean by future?
If there is an interference with private life in the sense of not being able to work and having not been able to work for 20 years, or legally work for 20 years, under Article 8, do you not only take into account that duration and that degree of past interference with Article 8, but also the potential future interference that will occur?
Well,
he's been deprived of his ability to work for over 20 years. And do you look at both past and future?
yes. And if you are, let's just say that this is a wide open balancing exercise. There's no determinative factor. You could imagine a different set of facts where they weren't responsible for their limbo. Then absolutely you could look at the future as well as the present. You could look at whether or not they have the capacity to work, whether or not granting them leave to remain would be something that would enable them to develop their private life. You can look at that, yes, or to develop their family life, yes.
Thank you, Mr. Dunlop. Very grateful. Mr. Drabble.
Lord and Lady, the basic argument I wish to advance can be taken in the following steps, which will immediately need to be qualified, but I'll set out the steps. First of all, the Court of Appeal decision in RA Iraq was correctly decided, and the guidance that it gives in relation to limbo should be approved by this court. That's the bit I need to qualify in the light of argument earlier today, but I'll do that. Secondly, the upper tribunal and the Court of Appeal correctly applied that guidance to the wholly unusual facts of this case. There is no error of law in either decision. They should stand together with the relief that was ordered. Thirdly, the reliance by the appellant in relation to ground 1 on the concept derived from Denisov that an individual cannot complain of personal, social, psychological and economic suffering which is a foreseeable consequence of his or her own misconduct is misconceived as applied outside the context of Gilberg and Denisov. The appellant's printed case, and indeed the argument earlier today, refers to this as the Gilberg exclusionary principle. This principle has been formulated by the European Court of Human Rights in an employment context, and the phrase, as I will show you hopefully this evening, is an extension of the concept of damage to reputation, firmly rooted in that area. The concept cannot be extended to an immigration or asylum context. Fourthly, none of the cases referred to by the appellant in an immigration or asylum context, either in Strasbourg or domestically, contain any reason contrary to the basic proposition I just set out in my first two principles, or support an exclusionary principle, I underline the words exclusionary, or a situation in which the fact that the situation is self-induced produces an automatic and universal answer. None of the case law supports that as a proposition that applies in an immigration or asylum context. Now, can I go slightly out of the order I'd originally envisaged? But the first area of debate is the Gilberg principle. We haven't been shown Gilberg, and it's actually quite important to get the genesis of the phrase that forms the learner friends ground one. So can I go straight to Gilberg, which your lordships and my lady will find at tab 21, page 1006. So it's in volume 2, for my purposes, not volume 1. And if we look at 106 and 107, 1006 rather, we have the report setting out the circumstances of the case. And reciting the fact in paragraph 9 that the applicant was born in 1950 and lives in Gothenburg. He's a professor specializing in child and adolescent psychiatry at the University of Gothenburg. And then if you jump on to paragraph 12, well, paragraph 11 refers to basic research projects, and the complaint was in relation to the professor's role, in relation to the revelation of the material that had fed into those research projects. Paragraph 12, the applicant alleged that the Ethics Committee of the University of Gothenburg had made it a precondition in their permits that sensitive information about individuals participating in the study would be accessible only to the applicant and his staff, and he therefore promised absolute confidentiality to the patients and their parents. And to short-circuit the summary of the facts, he was ultimately told to reveal the information, refused, and that was held to be a breach of his professional duties that led to the criminal proceedings, which are described at page 1013, paragraph 33. Then there's a long citation from the domestic judgments about general observations on the university's management of the case, including under the heading, the applicant's liability. That's the last full paragraph at the foot of 1014. The prosecutor has maintained that after the judgments of the Administrative Court of Appeal, the 11th of August 2003, and until 7th of May 2004, when the material is said to have been destroyed, the applicant in his capacity as head of the Department of Child and Adolescent Psychiatry willfully disregarded the obligations of his office by failing to comply with the judgments of the Administrative Court of Appeal and allow E and K access to the documents. According to the indictment, the applicant in so doing not only refused to hand over the documents in person, but also refused to make them available to university administration. So, criminal prosecution on that basis, and the applicant is convicted. And the final finding in this sequence of events, your lordships and my lady will find at page 1017, last paragraph of the indent, halfway up the page, the applicant's actions were therefore not excusable. On the contrary, for a considerable period, he failed to comply with his obligations of a public official arising from the judgments of the Administrative Court of Appeal. His offence cannot be considered a minor one. The applicant should therefore be found guilty of misuse of office for the period after the 14th of August 2003, when he was informed of the judgments of the Court of Appeal. So that's the background, a dispute in a professional employment context about a criminal offence arising from the failure to comply with an instruction of the court to give over the information. Now, the government submitted at page 1025, paragraph.
And the complaint was simply breach of Article 8. Is that right?
The complaint to the court, yes, so far we've been looking at the domestic proceedings.
Yeah.
The complaint was a breach of Article 8.
And 10.
And as we'll see in a moment in the, sorry, my lady.
And 10.
Oh, sorry, there was a complaint to 10. Yes, sorry, your ladyship is
8 and
completely
10.
right. Yes, and 10. The complaint under Article 8 is what I'm now coming to, because the phrase that forms ground 1 was actually Mr. Gilberg's lawyer's formulation of the extension of the idea of damage to reputation that was in play in his case. We'll see exactly what it was in just a moment. So paragraph 57 of page 1025, by way of a preliminary objection, the government contended the applicant's complaint fell outside the scope of Article 8 of the Convention and therefore should be declared incompatible with the Convention Vatione Materiae. More specifically, they contested that a criminal conviction could constitute an interference with the right to respect for private life under Article 8, unless there were special circumstances in a particular case calling for a different conclusion. Furthermore, recalling that the applicant was convicted of a crime related to his professional duties as a public official, the government contended that the applicant had failed to show how such a conviction had affected his private life or other aspects of Article 8 in order for his complaint to fall within the ambit of Article 8. And then this is the origin of the phrase which forms ground 1. 60, the applicant first complained he had a right under Article 8 not to impart confidential information, and this right had been breached by his criminal conviction. That was the Article 10 complaint. 61, he also contended that his moral integrity, his reputation and his honour had been affected by the conviction to a degree falling within the scope of Article 8, and that he had suffered personally, socially, psychologically and economically. On this last point, he had lost income because he'd been dismissed by the Norwegian Institute for Public Health and because he could have written at least 5 books during the time that could have been taken up by the case. And then there's a complaint about him being put in a dilemma. So the chronology of the case law in this area goes, you can't complain of damage to your reputation arising from the simple fact of conviction, because damage to reputation is a foreseeable risk of conviction, so you don't get an extra complaint under Article 8 because of it. Professor Gilberg says, I'm not just complaining about reputation, I'm also complaining about not being able to write my books, not being able to do part of my work. He stayed on as a university professor, in fact. I've suffered, in addition, it's personally, socially, psychologically, and economically, to use the phrase. And the case law says, well, damage to reputation alone stemming from the criminal conviction doesn't raise a case within the scope of Article 8, and neither does what I might call the Gilberg extension, the fact that it limits your employment activities in a particular way, fall within the scope of Article 8. None of the case law goes any further than that at all, and there is no shadow of a hint that this line of thought, which starts with the proposition, commit a criminal offence, your reputation will suffer, that doesn't raise an Article 8 complaint about private life. Do something similar that leads to your dismissal, that doesn't raise a complaint about private life. Do something similar in relation to a contract order, you evince an intent to breach the order in the future, that doesn't raise a complaint under Article 8. That's the limit of the case law in connection with this. And the court says, 65, pick it up in 65 of the judgment, 1027, page 65. It therefore remains to be examined whether the applicant's criminal conviction for misuse of office on account of having disregarded his duties as a public official amounted to his interference with his private life within the meaning of Article 8 of the Convention. And then the beginning of paragraph 66 says, private life, broad term, not susceptible to an exhaustive definition, covers physical and psychological integrity of a person, etc. And then 67, the applicant maintained that the criminal conviction in itself, and the words in itself are important, in itself affected the enjoyment of his private life by prejudicing his honour and reputation. The court reiterates in this regard that Article 8 cannot be relied on in order to complain of a loss of reputation with the foreseeable consequence of one's own actions, which is the foreseeable consequence of one's own actions, such as, for example, the commission of a criminal offence. And then 68, the applicant also contended that the criminal conviction had adversely affected his moral and psychological integrity, and that he had suffered personally, socially, psychologically, and economically. The court observes that the protection of an individual's moral and psychological integrity is an important aspect of Article 8. It notes, however, there is no convention case law in which the court has accepted that a criminal conviction in itself constitutes an interference with the convict's right to respect for private life. The conviction alone doesn't get you anywhere. The court does not ignore that such a conviction may entail personal, social, psychological, and economic suffering for the convicted person. In the court's view, though, such reproduction may be foreseeable consequences of the commission of a criminal offence, and therefore cannot be relied on in order to complain that the conviction in itself amounts to an interference with the right to respect for private life within the meaning of Article 8. So, stopping there, criminal conviction not good enough. That's extended to disciplinary submission, so employment sanctions in the course of a conduct of employment attract the same line of thought. You can't complain of damage to reputation. You can't complain of the knock-on consequences of, say, the dismissal in terms of damage to your social, economic well-being. But it doesn't go any further than that. And your lordships and my lady will see that from paragraphs 70 through to 71. In the present case, paragraph 70, the applicant was convicted of misuse of office in his capacity as a public official. His conviction was not the result of an unforeseeable application of that provision, and the offence in question has no obvious bearing on the right to respect for private life. On the contrary, it concerns professional acts and omissions by public officials in the exercise of their duties, nor has the applicant pointed to any concrete repercussions on his private life which were directly and causally linked to his conviction for the specific offence. Furthermore, the applicant has not further defined or elaborated on the nature and extent of his suffering connected to the criminal conviction. He did point out that he found himself in a dilemma, that he'd chosen to comply with the judgments of the Administrative Court of Appeal, with the result that he would be convicted of misuse of office. This confirms in the court's opinion that the applicant's conviction and the suffering it might have entailed were foreseeable consequences of his having committed the criminal offence. The applicant also contended that he'd lost income because he was dismissed by the Norwegian Institute for Public Health and could have written at least 5 books during the time taken up by the case. To the extent that it is to be understood as a claim, the applicant's conviction affected the enjoyment of his private life because of its bearing on his professional activities. The court considers that this form of economic consequence to be a foreseeable consequence of the commission of a criminal offence by the applicant, in respect of which Article 8 cannot be relied on. See paragraph 68, and we've just read paragraph 68. So in my head, and I still think this is inaccurate, my head is right, we start with the proposition that damage to reputation, which is the natural consequence of the criminal offence, doesn't itself found a complaint under Article 8. Professor Gilbert tries to extend that by saying, well, I could have written 5 books while I've been arguing about all of this. That's still a natural consequence of the situation in which he finds himself. You will not find a shade of this line of reasoning in an immigration or asylum context. And the references in, say, Denisov to the Gilbert principle are a reference to paragraph 68. They're not any wider than that.
Evers went a bit wider because it was the relationship with V.
Yes. Malone is entirely correct that it's not now just criminal conviction.
Right.
It's employment consequences, disciplinary procedures, and the contact order issues in relation to Evers.
Yeah.
But it isn't anywhere near, well, it's not logically related to a private life issue arising in an immigration context. And there's no hint in the Strasbourg case law that it is. I mean, I would say at once, there is no Strasbourg case law which refers to Gilbert or Denisov or any of this line of authorities in an immigration or asylum context. There is no domestic case law which does so. And indeed, my learned friend's printed case itself claims, recognises that there is no domestic case law applying the principle. So I thought it important that the court should see straight away Gilbert, because the whole phrase is lifted, I don't mean that pejoratively, but its origin is in the submissions made on behalf of Professor Gilbert. You're not dealing just with reputation, you are also dealing with these sort of social and economic consequences of the criminal conviction. So that is Gilbert, and what I'm going to do as shortly as is sensible in the remainder of the space today and tomorrow morning is just make good the proposition. It's a kind of search for a negative, that there is nothing in the case law, either in Strasbourg or domestically, that says that the approach in the upper tribunal in my present case contravenes some basic legal principle. It does arise on a very exceptional set of facts, and the tribunal was very keen to stress that. So I said I had 2 caveats about my original formulation. First is I do say that RA Iraq was correctly decided, and that the court said in the submission that the court should endorse the guidance. Various comments have been made in the argument about the guidance. If I can just say something about 2 of them. The first is whether it really is necessary to have the 4-stage process, whether that's just too elaborate. I don't mind, is my answer to that. The guts of the approach that I wish to maintain is the Court of Appeal stress on the need for a very careful factual analysis of the individual case concerned. That's actually articulated as step 3. And secondly...
Sorry, just on that, I mean, isn't that always the case in a proportionality balance?
Well, that's why I say I don't really mind. I mean, in a sense, I mean, what the Court of Appeal had to do in RA Iraq was try to make sure that there was a conventional approach available to a limbo case, which meant making sure that it was factually a limbo case. Having done that, then telling the deciding tribunal or administrator how to approach it. Now, I completely take the point that don't necessarily intellectually need a separate stage 3 and a separate stage 4, although my submission there's no harm in that. You have to do a very careful fact-finding exercise.
Why move away from the usual Article 8 questions? Is it engaged? Then you move on to, is it in accordance with the law? Does it pursue a legitimate aim? And then is it necessary in a democratic society? And then you get into the 4 bank milk questions.
Well,
why?
My submission is, I'm not going to the wall about whether you do the 4 stages of Article 8, of RA. What you must do is a sufficiently detailed factual analysis, whether you're looking at the proportionality exercise in the classic way that your lordship's putting it to me, or as articulated by the Court of Appeal in RA Iraq. It's got to be detailed enough to pick up both the similarities and, crucially, the differences that are present in the individual case from what one might regard as the archetypal case. Now, I mean, that may just be common sense. It may emerge from the fact you're dealing with difficult cases. I don't say otherwise.
But I was intrigued as to why, in this context, in immigration context, there is a need for that sort of these stages. And if there is a need, I would be really interested in finding out what it is.
Well, can I just go on then to my second point? I think my Lord Lloyd-Jones put to Mr. Dunlop that the possible criticism of the approach in RA Iraq was that although it does refer to the judgment of Mrs. Justice similar as she then was in Hamza, and obviously therefore was aware that you should be looking at whether or not the immigrant had cooperated in revealing details of his identity. It doesn't tell anyone what to do with the fact that that was a relevant factor. That's true, but one of the lessons of this case is that it reveals that the detailed factual analysis that was carried out might well reveal a situation which is different from the archetype, importantly. My learned friend said he wasn't going to look at the detailed facts, but you do have to look at the detailed facts that the upper tribunal regarded as relevant to why there was a particular impact on my client's private life because of his medical condition and circumstances. They are part of the background. The court did that, the upper tribunal did that, and it reveals the difficulty about giving more general guidance. I mean, maybe that I'm just agreeing with my Lord Stevenson on this. So it reveals the difficulty about giving more general guidance, apart from saying this is going to be relevant. It will often, i.e. failure to cooperate, it's going to be relevant. It will very often be determinative. I don't disagree with that proposition. But it doesn't follow there is an exclusionary principle or rule of law that is in some way breached by the upper tribunal's decision in finding that on these particular facts, having carried out the detailed analysis, it's not the archetypal position of non-cooperation, and the balance actually falls to be struck a different way. Now, exactly how any guidance that this court puts forward ensures that exercise is carried out is not, frankly, with respect for me to comment on. I can't take it any further than say be aware of the danger of being too prescriptive in the guidance. It's the lesson of this case. So, what I want to do in support of these positions is first of all go to RA Iraq and then to the upper tribunal decisions to pick up aspects of them that are necessary, and then I'm afraid to flog shortly through the case law in order to make good my negative proposition, which is that none of my submissions contravene any express or implicit logic in the case law as it's developed to date. So R.A. Iraq, that is at page 727. Page 727 is the head note. You lordships and my lady have seen enough of it now for me not to necessarily read any of this. But if your lordships just use the head notes as an agenda, the first point is that the upper tribunal had accepted that a failure to regularise might amount to an interference. To regularise a position in a position of limbo might amount to an interference with private life. And on the appeal, the head note recites, first of all, it's therefore necessary to distinguish. I'm reading about 10 lines into the holding. Necessary to distinguish in these two states when assessing the balance between public interest into deciding to report a prospective limbo is likely to weigh less heavily in the balance, but each case would depend on its own facts and the periods involved. And secondly, the foreign national should demonstrate that he was not capable of being deported immediately in the foreseeable future. It should be apparent that no further remaining steps were to be taken in the foreseeable future. And yes, and so there's a call for the fact-specific analysis. And then,
I think that's just summarising the four-stage approach.
it is.
It is.
Yeah, it is. Yes, I'm sorry, when getting it up myself, I'd use the head note to summarise the four-stage approach, but it's not new material. I completely agree. And then three is summarised in the head note, whether the conduct in part is a summary of the third stage, which does refer, as we saw in a moment, I'll take your lordships to it in a moment, does refer to the cooperation or lack of cooperation with
Whether their conduct in part caused the impossibility of achieving deportation.
yes. And that's straightforwardly taken into account as a factor. And as I say, our own perspective is that I accept that there will be a very large number of cases, possibly a majority of cases, in which a refusal to cooperate will actually produce the practical solution. That's not the question for this court. The question for this court is whether the upper tribunal erred in law in finding on the particular facts of this case that the non-cooperation necessarily drove the answer.
So whereabouts in R.A. Iraq, in the various stages, is the normative approach in the legislation and the rules worked into it? Whereabouts does one, insofar as you have a traditional method of dealing with Article 8 cases, that would have to be adjusted as far as the court is concerned, presumably to take into account the legislation, 117B and C, and also the immigration rules. Whereabouts does stages 1 to 4 include that that aspect?
I'm not sure that it does.
Should it? Right.
Was this a foreign criminal case? Can't remember. A deportation order. So
Yes.
yeah. So it was a foreign criminal case.
Yes, it was.
Yeah.
Yes.
Well, picking up my Lord's point, isn't it actually a flaw in this, the reasoning in this judgment, that there isn't reference to the statutory provisions which actually should govern the way in which the public interest is brought into account and balanced against the private interest?
Well, I mean, there is an express recognition, self-evidently at stage 4, of the need to carry out the balance. And we've seen from our own present upper tribunal case that the upper tribunal was very well aware of the statutory framework which had to be fed into the balance. I just don't accept what my learned friend says about it being missing from my upper tribunal case. It's very much there. So I think the position is that RARC is setting out the 4 stages for approaching a limbo case. And I suppose I accept that it assumes that the expert tribunal that's applying it will be aware of the background analysis if you are dealing with the background requirements of the statute, if you are dealing with a foreign criminal case.
I wonder whether it might be said with respect to the Court of Appeal in this case that to give general guidance in this way without referring to the statutory framework in which the balancing exercise has to be performed in this context might be thought to be distinctly unhelpful.
Well, I think I've used this phrase more than once already today. I don't mind, because the answer that we actually come to is that the upper tribunal, whose decision I say contains no error of law, was aware of that statutory framework, bore it well in mind, and having used the 4 stages to guide the analysis, then produced an answer to the Balancing Act, which is compatible, which took fully into account, not as compatible with, which took fully into account the statutory scheme.
But your first submission was RA is correctly decided.
Yeah, well, RA was correctly decided.
And you said
I completely accept that the formulation of my first point, or second point, whatever it was, invited the court to approve the guidelines. Now, that doesn't mean I'm not going to stand by the guidelines being necessarily complete. But if what one is doing is identifying ways in which the guidelines are not as complete as they might be, it doesn't matter for my failure or success on this case unless the upper tribunal has failed to deal with the missing points, which it hasn't. It may have got there by itself without help from the guidance in RA Iraq, although it was plainly considerably helped by the systematic approach which RA Iraq encouraged. And having done that, it was fully aware of the provision relating to foreign criminals and the provision relating to little weight to be given to private life, and fully aware that that didn't produce the final answer, as Rupiah itself demonstrates. So my submission will come tomorrow morning now to look at the detail of the upper tribunal's reasoning, and even if it's not as informed as it might be by a more complete RA Iraq, no one's falling into any error in this case as a result. And before I sit down, because it's pretty well 4 o'clock, we saw already that if we go to paragraph 71 of RA Iraq,
I think it's page 740.
It is page 740, yes.
Yes.
And 71 and 72 is actually 72, which is a citation from Hamza. It plainly feeds into the analysis, the issue of whether or not someone has cooperated with revealing information about their identity. I repeat the submission that neither Hamza nor Abdullah nor any of the other domestic cases form the basis for a submission that you can never reach a limbo stage in a self-induced case where the answer must be a refusal.
All right.
I'm Lord, I don't know whether that is a convenient
Well,
one. It is for me, and I'll...
If it's a convenient point, Mr. Drabble, we'll adjourn now. We will resume at 10:30 tomorrow morning. Very grateful to you and Mr. Dunlop. Thank you very much indeed. The court's now adjourned.